Now let's speak to a legal mind to break the matters down for us. Lawyer Bobby Banson is a private legal practitioner. He has deep understanding of matters like this. He joins us on the line. Hello, good evening, sir. Welcome to Eyewitness News. What's your first impression, or your general impression, on the ruling by the Supreme Court today in the matter of the Speaker seeking to get the Supreme Court to vacate its own orders or ruling made a couple of days ago?
Good evening, Shalom to you and your listeners. My first impression, and I had the privilege of being in court when the ruling was being delivered, and prior to that when the arguments were made. My first impression of the ruling is that it is very solid. It is very solid on the basis that it covered every single issue that had been raised in the contentions that had been summarized in the application that had been filed to set aside the orders made by the Supreme Court on the 18th. And so the Supreme Court, with the lead judgment the ruling read by the Chief Justice, addressed each issue that had been raised and then provided its reasons why it disagreed or agreed with the positions by either the applicants or the respondents on the other side. So I think it's a very solid decision that has been rendered.
I see, but let's delve into portions of it. I mean, the reasoning really. So the Chief Justice or the Supreme Court makes the point that constituents in those four constituencies may suffer irreparable damage should the seats be declared vacant now. I mean, for which reason they want to give an expedited hearing on the matter. But is that not what it's supposed to be? If an MP falls foul of the law and so comes in breach of the Constitution, the seat must be declared vacant. And indeed, in respect of this particular matter, the Constitution tells us in 112(6) that a by-election shall not be held within 3 months before the holding of a general election. Clearly, the Constitution contemplates situations where people will be left unrepresented. So why was the Supreme Court, going on and on about this particular matter of no representation for a period of time?
Well, the Supreme Court was of the view that before you can deny people that representation, you must come first to the conclusion that a member of parliament that has been elected by the people has breached the provisions in the articles that are the subject of the suit. Now, the Supreme Court is the position that as it stands now, because of the varying interpretations that have been put on that particular article or those articles, you cannot come to the same conclusion that the members of parliament had indeed gone ahead to breach those constitutional provisions. So do not hasten in concluding that they have breached, and then you are denying them, the constituents, the right of representation. Let the Supreme Court go through the process which had been initiated by Honorable Afenyo Makin to confirm the interpretation, either that of the Speaker or that of the Majority Leader. Either way, whichever interpretation the Supreme Court will arrive at, if the Supreme Court concludes that the interpretation by the Speaker is right, then the Supreme Court will proceed to announce that the Speaker was right, for which reason the persons would be denied the representation as provided in the Constitution. However, if the Supreme Court holds that the Speaker's interpretation is wrong, then it means that the people the constituents will now not be denied the representation. Now, the Supreme Court said, between now and when we give our judgment on the substantive right, do not deny the people representation, because if you proceed to deny the people representation based on one side of or one interpretation, you would have gone before us, and the damage that would occasion these people cannot be repaired in any form or manner by way of damages, or you can't reverse all parliamentary proceedings between now and then and now let the people come back. So the Supreme Court was of the opinion that the Speaker of Parliament has given one interpretation. Whether we call it interpretation or not, the Speaker of Parliament had delivered a ruling based on his interpretation. Somebody says that no, this interpretation is wrong. I think this should be the interpretation. So at that stage, there is definitely varying interpretations, and so the Supreme Court's jurisdiction has now been invoked to interpret. So what the Supreme Court is saying that until we finish the interpretation, none of the interpretations should be enforced, either by the majority or by the speaker.
About when services or processes could be served on members of the House or the House generally. Based on that circular, my understanding is that the Speaker or Parliament refused the service. But we see the Supreme Court today go on and on explaining that we should treat it as the Speaker having been served. What do you make of that? We agree on one matter, and then in another forum, the principle changes. Indeed, there was a practice direction, signed by the Judicial Secretary to that particular effect. What do you make of all of this? Where will it stand?
First, it wasn't a practice direction. It was a circular that was issued by the Chief Justice. So it doesn't have the weight of a practice direction. 1. 2, the Chief Justice actually took the opportunity to clarify the circular. First of all, the argument that circular as an administrative does not override the provisions of the Constitution was clarified by the courts. In their ruling somewhere, they made mention of that. But more importantly, I heard the Chief Justice say that if you look at the circular, assuming you are going by the argument of the circular says that if you want to serve the Speaker personally, that is, you want to go and give it to Mr. Bagbin himself, you should do that on Monday. However, if you want to serve on the legal department of the parliamentary service, you can do it on any other day. So I believe when the bailiffs went there, they went to serve the legal service. So is it the legal department or legal director?
Legal department, I think.
The legal department of Parliament. So it wasn't as if the bailiff went to look for Mr. Bagbin himself to serve him. So the Chief Justice clarified those two columns in that circular and said it is not true that I am now departing from the circular. The circular stated that if you want to serve Mr. Bagbin himself, you do it on Monday. But if you want to serve Mr. Bagbin through the legal department, which is allowed because we know that the Speaker is not being sued in his personal capacity. And so in that event, you could serve the legal department of Parliament. If you want to use that means of service, then you could do it on any other day. So that is how I heard the Chief Justice or the bench explain that circular. But the fact that the circular does not override constitutional provisions was well settled as well.
I see. There were some other issues, prior to the ruling itself, which also occasioned some ruling of a sort. The recusal or the application for one of the members of the panel to recuse himself because they felt that he had ties with the governing party. What do you make of that application, and what do you make of the ruling of the court?
I thought that application was rather interesting. My argument, and I agree with the ruling by the bench, that, listen, Parliament is the only institution under the Constitution that approves the nomination of anybody to the bench as the Supreme Court judge. This issue of the political alliance of the judge in question was raised before Parliament, and yet he was subsequently approved. And so if you file a matter before the Supreme Court and you now use that same reason as the basis for your prayer for that judge to be recused or for him to recuse himself, then you are revisiting an issue that has been well settled by Parliament when there is no basis for the Supreme Court to review that decision of Parliament. Secondly, the MPP as a political party is not a party to this suit. There is absolutely nothing on the face of the writ or the processes that have been filed that states that the MPP has an interest in the matter, and this judge is still a member of the MPP, for which reason he would have influenced or taken any direction from the MPP in respect of this. In any event, when the judge appeared before the Parliament, he stated clearly that he had resigned from the party, and there was no contrary evidence that was adduced today indicating that he is still a member of the party, for which reason his decision or his judgment will be biased or influenced by any colorization. And I heard the Chief Justice also make mention that if you go to the judicial system now, there are former high-party ranking officials who are members or judges, and yet, nothing is done, or there is no evidence that it has influenced or affected their decision-making.
I see. Thank you so much, Bobby Banson, for helping us appreciate the matters. But before you go, where does this leave us? I mean, where do we go from here?
Well, I was happy that the bench appreciated or took judicial notice of the sensitivity of the matter and the need to resolve it. They have adjourned it for their decision of, as they call it, the hearing. They have asked the Speaker of Parliament, if he's so minded, to file his statement of case in response to the statement of case, which has already been filed by the plaintiff and the Attorney General, who is the second defendant. And so we would see a very quick resolution of this matter. And we'll all be interested in the decision of the Supreme Court as to the interpretation of those clauses. Remember, the issue of whether or not the Supreme Court has jurisdiction in the first place was also raised today. And I believe that in delivering the judgment, the Supreme Court would fully go into that matter as well, even though the ruling touched on some aspects of that issue of whether it should go to the High Court first or the Supreme Court.
Speaking about the ruling generally, I mean, what do you tell lay people who say that upon hearing the Chief Justice or the court's ruling, it's quite clear where the direction of the court will be in the substantive matter? What do you say to persons like that, even though the matter hasn't been fully argued? This is more or less an interlocutory matter, if I may call it that way. What do you tell such people who think that listening to the court today, it does appear that the Supreme Court is clear on where it's headed?
I'll be very surprised with that argument, because I didn't see or hear the Supreme Court make any pronouncement on the substance of the writ. I didn't hear that. And so all the interlocutory matters, the rulings that were delivered, were limited to the issues that were before the Supreme Court at that stage. And none of the issues before the Supreme Court that were determined today touched on the substance of the writ. So those who are making that argument, as a lawyer or as a student of the law, I don't think that it has any factual basis on the back of the proceedings that I listened to personally in court today.
Thank you very much, Bobby Banson. Bobby Banson is a private legal practitioner. He's been helping us appreciate the decision of the Supreme Court today. This is Eyewitness News on 97.3 City FM.